Hi, welcome to the TechTicker Show. I'm Nirmal Bhansali and I'll be your host for this podcast. This is an extension of our monthly newsletter, The TechTicker, which focuses on law, policy, and technology. In this episode, I'm speaking to Manu Kulkarni, who is a partner at Poovayya Co, where he heads the dispute resolution practice. Manu has been litigating at the sharp end of tech law in India for years. He acts for some of the world's most prominent platforms in courts across the country. In this particular episode, we're speaking about all things tech regulation, from the arc of internet regulation to some of the recent conversations which are taking place around misinformation and social media bans. I hope you enjoy the show. Hi, Manu. Thank you so much for joining the TechTicker Show. This is the first episode, and I'm really excited to have you here to kick things off.
Hey, hi Nirmal. Thank you so much. I look forward to a engaging discussion with you.
Yeah, so I think the place where I want to start off, we're going to talk a lot about platform regulation and there is sort of recent developments taking place with misinformation in our country. But the place where I want to start off is actually to set some context of how you have seen internet regulation evolve from the 1990s to now, and how in your experience as a litigator you've also kind of seen that transition globally, and if something different is happening in India. I think that's where I want to start this conversation off.
So, if we look at India first, when the Information Technology Act came in 2000, law I think was then an instrument of enabler of technology. Right from the preamble of the act to the discussions to what inspired the statute, it looks like the law wanted to bring about parity between paper and electronic record. That was the focus of the legislation. Enable digital signatures, give recognition to electronic contracts, prescribe in what circumstances electronic documents are as good as regular documents. That's the first decade, 2000 to 2010, shall we say. Looks like by 2009, and the reason why I say looks like is the parliamentary debates are not specific or pinpointed or certain, but one can figure out from the whole scheme of the law. Looks like by 2009, the mood had changed from saying, okay, now law has sufficiently enabled technology. Now law must also start or begin to regulate. That perhaps was the decade of 2010 to 2020. You have the 2009 or 2008-9 amendments to the IT Act, followed by the 2011 rules for intermediaries. For the first time there were rules. Followed by what I think very significantly, but something that otherwise we don't sufficiently highlight, the 2019 Consumer Protection Act, which brought electronic commerce under the category of consumer protection. You know, the name says it all. It is meant to protect the consumer. To now, the decade of 2020, I think, is going to be, or it looks like, is a decade of regulation for the internet, perhaps the decade of enablement for AI, at least in India. That's the 3 decades, and really 25 years old in India, the law.
Do you think like this trajectory is also parallel to the world as well, like larger economies in the US where perhaps you could say the early internet regulation took place? Do you think we're kind of following the same movement there, or globally also you feel like this is the path that has been, like this is the largely the arc?
Candidly, Nirmal, because the internet in some sense was founded and became most prevalent first in the United States, this is not the trajectory. The earliest cases in United States are from 1970s and 80s, but they're not necessarily about the internet. They're about copyright over software programs and things like that. The earliest cases are 70s and 80s, which is why Section 230 comes in 1996, prior to 2000, by which time there is already some case law on bulletin boards, and there is a risk of development being throttled, development of the internet as we know it today. That's why 230 comes in 1996. In fact, I, because you had given me sufficient advance notice, I pulled out a few sentences from Lawrence Lessig's code. He wrote that in 99, if I am not wrong. He refers to a very interesting article which I am told was the rage during the 1990s. As a child then, but it says this is early days of the internet. This is what people were thinking, dreaming, imagining. You weary giants of flesh and steel, I come from cyberspace, the new home of the mind. On behalf of the future, I ask you of the past to leave us alone. You are not welcome among us. You have no sovereignty where we gather. So in the early days, now there is some rumor that this was when this sentence was written by John Perry Barlow. I don't know. I don't want to trade in rumors, but these were the early days. Lawrence Lessig says this: the early imagination about the internet. It was the withering of the state that Marx had promised, jolted out of existence by trillions of gigabytes flashing across the ether of cyberspace. Cyberspace, the story went, could only be free. Freedom was its nature. So the early imagination was internet will create a scenario which is supranational, where there will be no law. But like all developments in science and technology, ultimately some sort of anarchy is risky. So I think therefore the trajectory in that sense, if we now go to Europe, our Information Technology Act is inspired by the European regulations, where the focus was just the same, to bring parity between paper and electronic record. So we see, by now I think the trajectory has evened out. Now that tech is available equally across the world.
We're also kind of starting our own path now, and we're not kind of maybe not relying, but figuring out perhaps our own way of now regulating tech, where we don't have to seek constantly at least what's happening globally, apart from reference, of course. I think this is helpful. Now, you mentioned, a few things, Section 230, I'll definitely come to that, and how courts have viewed the internet from being this open space to now we are seeing it to be a little bit siloed. The place where I want to start off from here, now that we have some context of what India's trajectory looks like, what it has been, is the ongoing conversations around misinformation and AI, which has taken over, any other issue that we see with respect to regulation in the country. I think the place where I'm keen to hear your thoughts on is, now we know that this AI generated information is coming. We're seeing a lot of misinformation happening. What are some responses, regulatory responses that you're seeing are perhaps working, and where do you think we're kind of lacking, right?
So Nirmal, I and you were both in a conference where the Honorable Minister gave a very simple example of misinformation, that India's national anthem is ranked the world's best national anthem. He says this is misinformation. So misinformation comes in various categories. Misinformation is popularized by what we call, I'll not take names, blank university. Every morning we know people at home read stuff that is perhaps true, perhaps not true. But tell me this, very philosophically, do we ever really have accurate information? And it's not just me. Let me just read out one quote by Mark Twain. He says, "The history of our race and each individual's experience are sewn thick with evidences that a truth is not hard to kill and that a lie well told is immortal." So therefore, realistically, when we look at things, today there is a conflict going on in the world. It depends on which news channel you see, and you will get a different version. So when we debate about information and misinformation, I think the most critical part that we miss out is there is no single custodian of information. And if there ever is one, that is propaganda. In that, the reason I think it's important for us to contextualize this debate is because quite a lot of the time, a point is better made in parody, in satire, which can easily be branded as misinformation. There is a science fiction author called Ursula
Le Guin.
Yes.
Ursula Le Guin.
So she has written a book called The Left Hand of Darkness. She has written a book called The Dispossessed. She simply creates another universe right next door, in space-time. It's easier for us to see our own fault lines from there, from up above. Now, tomorrow something like that will be termed misinformation. So therefore, if we come down from that spatial perspective to the brass tacks, a lie is told in 100 different ways. A lie is told by printing a pamphlet, by circulating a message, or by creating a video. Some of those are harmless, some of those can and certainly are harmful. It is not the means that is the problem, it is the intent to commit crime which is harmful, and that intent has always been there. That intent, because we are all human beings, will be there. So therefore, I think we are making a mountain out of a molehill because we are afraid of the unknown. As human beings, we are naturally, instinctively afraid or concerned about the unknown. This is new tech. Therefore, we are more concerned than we should be, is what I believe.
Interesting. So if we look at the means and the intent, right now we could say regulatory movements are addressing the means. The SGI amendments, which came out literally just last month in Feb, they're looking at imposing certain compliance obligations on a platform to identify or to make sure that the user at least is telling you that this is a generative content, or this is a piece which I have made some modifications for. Even we in the policy dialogue that we had, there was conversation about how certain states are looking to make platforms, or at least the people through which you're transporting that misinformation, to take responsibility. So I'm curious to understand, like, if you say that it's not that big of a problem, it's something which is just human nature, but on the ground it seems to have certain implications, right? What kind of implications do you see when I make means the place where the regulatory choke point? Do you think that causes implications? What kind of consequences do you think arises out of these kind of regulatory movements that we are seeing right now in the last few months?
So, Nirmal, I think you got it right, but just to make myself clear, with every new technology, there will be people who will abuse it. All I'm saying is, it's not the technology that's the problem, it's the person who would like to abuse it that's the problem. And every new tech simply provides a tool to that person. That person has always been there, historically, up till today, and will be there in the future. All I am therefore saying is, it is not as if the technology has created a Frankenstein monster, not at all. So bad actors have always been there. Now the problem is, especially some case law very poignantly say that when there is a difficulty, when there is a problem, the law must be measured. The law must not sweep so broadly that the baby is thrown out with the bathwater. Long story short, and that has always been the law. Proportionality has been the running thread, although that word may not have been explicitly employed until the recent past, or until, say, about 2 decades. An excessive focus on the technology, I think, will sweep too broadly. A requirement of labeling everything, labeling every content, imposes sometimes an impossible burden, which may make technology itself unavailable. And there are, for every person who intends to misuse technology, there are 1,000 benign uses, and because they are benign, they don't make news. Somebody was telling me from my town that a very well loved and well respected teacher had passed away, and they were making efforts to collect videos and photographs of the teacher to reproduce some of his tuitions. Things like this won't make noise, won't make nationwide news. They'll just be relevant in my town where the teacher was well loved and well respected. So I am concerned that in making broad-based or broad-brush regulations that don't target the misuser and target the technology, that focus of the law may prevent innovation. And the fact of the matter is, innovation anywhere in the world will seep in here, sooner or later. That is the reality of life today. Then should we not have an environment that encourages innovation by the law focusing on the misuse? Would be the question that comes to me.
Would you say, like at this stage, I think the concern which I feel like maybe, in conversations which I have, let's say, with my parents, etc., they are also worried that some harm is being caused, or, something bad about the way the information ecosystem is right now. And perhaps this is why you have governments across the world, not just in India, trying to react and target the tech itself, target the place where you see this arising. So if I'm not supposed to target the tech, what are the things which I can do to make sure that those bad actors are penalized, are sort of punished, or there's some justice, so to speak, taking place, right? What can we do then? What can we improve? Is there something which you think within our system that we can kind of do better, which we're not doing right now?
First, I think the assessment of how much harm something is causing is quite often driven by how much reporting there is about certain harms. So, for example, most of us rarely have, I don't say I have, but most of us rarely have empirical data on whether physical theft or robbery in terms of value is more than digital arrest. Most of us don't have the data because a phenomena is new, it is talked about more. The fact is, if we empirically examine how many thefts have taken place where theft is proved but there is an acquittal because the offender is not known, it is that kind of rigorous empirical analysis which will tell us where the fault lines are. In my view, the easier of the solutions is to say, don't provide for mobility because mobility enables a thief to steal. It's easy. As a system, a systemic response to say we will fight crime better is always hard. Nobody is saying it's easy. And therefore, that's not the most obvious solution because it's not going to bring results immediately. It is going to take time. It is going to be a slow, painful process. But that's a surer system because technology will change in 5 years from today. It will change in ways that we cannot imagine today. And I am not saying this. I have friends in the Silicon Valley who are people in the technology world, who are inventors. They cannot predict. It's not me. So therefore, law's reach then is going to be limited when technology keeps changing. Therefore, the answer in the law is always a firmer enforcement and use the same technology to enforce. But, frankly, me saying it not being a part of law enforcement sounds platitudinous. It's not fair. There are difficulties, there are huge difficulties, but we also see a lot of effort that goes unnoticed. Law enforcement does a lot of things to actually catch the bad actors. They don't make news because it's not newsworthy then.
What do you think are these difficulties that is not allowing us to enforce our existing framework better, like especially in the context of internet regulation? Like, what are these difficulties? Maybe some examples. Like, what do you think is is the problem that, let's say, a police officer is facing or a magistrate is facing, that they're not able to, maybe they want to do something but they're not able to?
See, at the top, the most generic problem that no expert about this, that everybody in the system says is, for example, our police force is understaffed. Our court system is understaffed. We don't have just enough number of people to man these situations. But those are generic problems. More specifically, I don't think we have sufficient, or we have sufficiently, I cannot even say invested. I don't think we have had the time to sufficiently develop a force that can understand all of this and respond, that can understand technology and respond. And I don't think it's a problem of either intent or a particular government. I just think, for 140 crore people, it will take time to catch up. It will take time for us to have enough number of police people, enough number of judges, enough number of lawyers, enough number of doctors. We are getting there, but I think the problem is really more generic rather than technology specific. But in the technology era, I think, as is usually the case, it takes time for law to catch up. The bad actor does it first, the law catches up, and it is always the case. See, look, let's just go back 15 years ago. Piracy of software was such a prevalent phenomenon. Everybody knows it. Little by little, it was curbed. Pirated books were sold on roadsides. That has come down. So the person who wants to pirate will do it first. The law will react, the law will respond. And usually the law catches up, and when it catches up firmly.
Would you say, I mean, and like, given the kind of potential harms that, you're right, perhaps the assessment and empirical data of harms might be limited. We have some data, maybe not as comprehensive as we'd like to be. But I think regulators are also are concerned about these harms. Like, that's so. I don't know if they want to be catching up to this at this stage. Like, the rapid pace of technology is so much now. I would, at least my personal views, I would argue that the last few years, the way it has evolved is maybe an entire 20 years compressed, right, in 3-4 years. At that stage, wouldn't it be fair for a regulator to keep up as opposed to wait and watch?
What you're saying is perfectly justified in the sense that every regulator will want to catch up today rather than tomorrow, and now rather than today. Perfectly justified, perfectly legitimate. The two questions that I see are, what is the means? Because the means should not distort the ultimate goal of technology, which is, it's a life enabler today. So let's look at it like this. 30 years ago, if I had to write something, unless I knew a regular publisher, I would have had no access. But today there are there are lakhs of people from the smallest corners of this country. So internet has democratized access in ways that we cannot imagine. The content that we consume today, some meme, somebody in some small town in an otherwise unknown place in the country, I am able to access their content, they are able to access me. Now, this is not talked about often because in some sense it is not newsworthy immediately. So the problem is, a broad-based regulation can also curb this. We have to find ways where this is protected, because again, when we talk of information and misinformation, really, Nirmal, the number of times textbooks change, we know that it's hard to say this is the only way to look at anything. It's hard to etch truth in stone. There will always be versions, there will always be narratives. When we try to curb some kind of information, we may also end up curbing narratives. Traditional wisdom has always been, let narratives be. The more truthful narrative will eventually succeed. That is, in information versus misinformation, so that information succeeds, has been the traditional paradigm, and that paradigm has worked for over 200 years all around the world. There is no reason why that paradigm should be let go of today.
Would you? I think this also, it was an interesting thing which was brought up in the dialogue that you had attended, which is that the marketplace of ideas right now, of course, more information can beat false and misinformation, but perhaps there's also now the worry that this is not happening as much because the way algorithms are constructed or the way people are consuming information, you're not seeing the most truthful ideas win out. You're just seeing the ones which are the best, which can get the most eyeballs, which can get the most attention.
Winner takes it all.
Yeah, winner takes it all in a way. And in perhaps, I guess the worry, or do you see this as a worry that if winner takes it all is the paradigm, and we have certain harms, certain problems accruing out of the way information is being portrayed, at some point, like, is it okay to just let that be, like, just let it allow and see what happens? Maybe like we're just growing and we'll probably figure out the newer marketplace, or there'll be something new which will evolve. Or as we are seeing right now increasingly around the world, where they're trying to control how much you can also say as a user, right? Like, what do you want to communicate? Maybe we restrict you from posting certain types of ideas. I think I'm just curious about like where you see this. Like, we are seeing the marketplace of ideas being challenged in a way, right? The way we thought of the platform originally, the earlier internet of the 1990s, definitely now has changed a lot. Might require a different imagination than what was traditionally happening in 200 years.
I think, and I genuinely think, you please tell me if I'm wrong, that our concerns need not be so, because that is not how the internet is functioning. Let me give you a few examples. Shakespeare was popular yesterday, Shakespeare is popular today, will likely be. I don't think anybody on the internet has, merely because of reach, suddenly attained bigger popularity. What it has done is, it has increased the speed at which somebody will become popular, but it has also increased the speed at which somebody will be as easily forgotten. So all it has changed is the means. I don't think in the end it has changed anything. And we look at life. Kannada is one language which has had perhaps the maximum number of Jnanpith awards in India. There are some authors whose poetry is still recited at home, set to music. And there are some authors who may have won the award but who are now confined to university classrooms. None of that is a function of the internet. It's a function of what their literature is about, and nobody saying something is better, something is not. I don't think, if you look at hard statistics like this, I don't think the internet has changed anything so drastically. I don't think AI has changed anything so drastically. It's just that what we see immediately sometimes has a tendency to make us more concerned, I think, than we should be. But this is all from one perspective, which is from the perspective of the person who is the recipient of information and how to ring fence or safeguard that person. The other problem, which in my worldview and which perhaps in most people's worldview is a bigger problem, is who are the persons who are going to decide what kind of information should be available or should not be available. Because let's be very, very clear about one bit. Any person who gets to choose what kind of information is available will usually prefer information that is laudatory of oneself. I am not even saying untrue. Laudatory truths. Oh, I got a medal in so and so, I want everybody to say. I flunked the course, I don't want anybody to say. Now, the problem is both are true. So if I want only the first, and if I somehow am able to say the second is untrue, the first is true. The first deserves to be said. It's just that the second also deserves a mention for somebody who's interested. Truth of the matter is nobody is interested in me. That's a separate point. So therefore, what is and what can get really risky? For example, a bill that was circulated in Karnataka, we don't even know if it was authentic, but if we take that bill as the model, there are persons from the government who wish to decide, or who will be on a panel which will decide if something is certainly misinformation. That's extremely risky. It's risky because in a democracy, government never gets to tell you what's true, what's false. In fact, case law says government cannot sue for defamation. Across the globe, that position of law, I'm not saying government servant, government institution, never gets to sue for defamation, because we are entitled to say, criticize, or we are entitled to say things that may not necessarily be accurate. So the bigger part of the problem is who gets to decide, who gets to choose. And if we can't find that, the easier thing for the law is to focus on the bad actor. That ways, the law will steer clear of these huge systemic risks.
This also helps me also talk about like some of these proposals. You mentioned Karnataka, which was passed around sometime earlier last year, but we also now have a state like Telangana, which is looking at potentially introducing a similar type of legislation as well, which seeks to regulate hate speech online, perhaps, and we don't know the exact details, but is looking to regulate it in a strong way. It's the states now which are entering the forefront. We did have a central law. We had the government with the IT Act, and since you mentioned this, who gets to decide is an important question. Why or where do you see states coming in? Why do you think states are kind of entering this field now? We already had this. I mean, we have had a central government, for the last 25 years. We've had some rules. In your earlier, you've also written about how our existing framework of criminal law is sufficient to deal with this problem. It's not as though it's not. Why do you think states are entering in this space? And perhaps more importantly, do you have any thoughts on what they can be doing or what they can be focusing on instead?
So, if we take, for example, the hate speech bill that the assembly in the Karnataka passed, since I've already written about it, and I have studied it, I can say that law is unlikely to pass constitutional muster, for the simple reason that, one, central government has largely covered the field. Two, there are provisions in the Indian Penal Code, then BNS now, which perhaps have a stronger definition of what is hate speech. So then, therefore, the law perhaps is unnecessary. The existing law is sufficient. The question then is, what's the motivation? One thing we have to do is a sober public debate. We should not needlessly question motives. So let's keep aside the motive, because that simply increases the decibel level and reduces genuine discussion. The motive perhaps is, the concern is there is a new form of crime. Let's take, for example, speech that can cause unrest among communities. Certainly that's not the kind of speech that we want. Of course, we want criticism, we want open discussions, but not something that can, as they say, spark in a powder keg. Now, is there law to prevent it? Oh, most certainly there is. Then why is it that the states want a new law? Why are they hankering for a new law? Frankly, I think because the old law has not been used sufficiently. Same is going to be the fate of the new law. There is no reason why the new law will be used more than the old law. So instead of writing, provision 4(1) of Hate Speech Act, you will write 153A of IPC. That's all. That's the only difference. Unnecessary. But the risk is when a new law like this creates a committee, and that committee starts getting to decide whether some information must be taken down, one runs a serious risk of eroding free speech. And erosions always begin like this. I am not even saying they are intended to erode. They are reacting, I think, unnecessarily to a problem. This is not the solution. The solution is really making sure 5 bad actors are taken through to conviction. It is also not the quantum of punishment, it's conviction. 5 bad actors are convicted, the 6th person will be careful. 2, I genuinely believe, as a people, as a society, we should be a little more thick-skinned in our country. If we look at what the courts have repeatedly said is the standard of the person from whose point of view speech should be analyzed, it is a courageous person who does not scent danger in every word, a firm-minded person. So the standard or the bar by the law is fairly high, but in practice, I think as a people we've become, there is to a certain extent this outrage culture, and law enforcement is genuinely concerned, I'm not saying not genuinely, that sometimes outrage is the beginning of people taking the law into their own hands. That is where I think as a people also we need to sober up. We need to say, see, look, some criticism being made, even if it's harsh, is to be countered by truth. It takes time, but more mature societies respond to uncalled for criticism in that fashion. So to put it in perspective, these new laws are unconstitutional because central government has occupied the field. They will invariably conflict with central law. They are unnecessary because the law today provides sufficient remedies. And fourth, any remedy apart from criminalizing hate speech is likely to run into huge constitutional questions.
The other, like you mentioned this, and this, I think this is going to be one of the tussles which we will perhaps see in the future. The other kind of proposals which are increasingly being considered in India but around the world is also another type, like a social media ban, like banning the platform for kids under the age of 16, or like some demarcation on kids under the age of 18, etc. You have like 40 plus countries considering this. We've seen some states which have made statements, or they're at least potentially looking into whether they should be banning social media platforms for kids within their own states in either the education system, etc. I bring this up because this is also another type of regulatory proposals which we're seeing. Wondering if you have any thoughts generally about like a social media ban first, and I have some follow-up questions from there. What do you think here? Like, again, the center does not have a law for this. The center hasn't said anything. So do you think it's good for a state to come in like a Karnataka tomorrow or a Maharashtra tomorrow saying, within our state, if you're a child under the age of 16, you shouldn't be using the platform, or the platform will be liable if they see. Do you think something like that would be possible? Is that something which is potentially possible as a constitutionally? Is that possible? And then secondly, what do you think would be some of the consequences which you see arise out of this?
Well, first we have to define what a child is correctly, because In law today, a child is anybody below 18. But to say anybody below 18 cannot have access to social media, I don't think is ever going to possibly take place. Which is why I think very correctly you said 16. Now should 16, if somebody thinks of a law also, should it be 16, should it be 13, if at all there should be one, that itself is a question. During COVID, we have seen so many parents being notified of classes, of postponement through WhatsApp. Many a times children are there because one parent is on her way to work, the other parent is attending to something else. So sometimes children themselves have to be notified. So the reality of today's life is everybody is on the internet all the time. Many people don't subscribe to physical newspapers anymore. Their news is on a device. That device invariably has access to social media. So therefore, I think the idea of a ban is extremely risky. Look, how children are to be brought about, no two households are the same. Every parent decides differently. This model where the state will tell the parent how to bring up the parent is not necessarily a good idea. In fact, it's a very risky idea. It's one thing to say one's going to prohibit. It's another thing to say, do we have enough tools that a parent can decide what my child will have access to, parent, guardian, by whatever name called. I think that is a better model because it seriously infringes on somebody's choice of education. And see, one thing that we must always consider, especially in India, is internet has massively democratized access. When I was a child in my town in North Karnataka, the source or access to information was quite limited. Today, there is genuinely no difference because everybody has access, and access at a very low price. Now, access at a very low price, to a certain extent, we must give the credit where it is due, is also because of the good policies that our successive governments have followed. Now, this democratization of access can sometimes mean access to information, educational material that otherwise children will not have access to in a sanitized environment. For example, if you say social media is banned, now somebody wants to learn about, say, what was the reign of Samudragupta like? Why did Kalidasa and Shudraka come at or about that time? Why did a king become a poet or a playwright? Answers to these questions may not be readily available, but these are relevant questions. So, in a country like ours, where access can really change between one place to another, we must be extremely cautious of thinking of an overall ban. If you ask me, a more constitutionally permissible paradigm is to enable the parent, and I think that technology is already there.
I understand. I think we should be able to enable parents, and also this idea that you shouldn't be telling a parent how you should be parenting, right? Like you don't have the authority to kind of do so. Increasingly, and here is where I do want to refer to like a couple of like recent decisions in the US. It's the Los Angeles court which has said that look, the tools which the technology provides for some of the platforms, they're harming the child. The way these platforms are designed, it's so addictive. The algorithm which is being used by the platforms is making the child use these platforms a lot more. And this is where the tension, I think, is there across the countries as well, who are considering like a social media ban. We're seeing this kind of conversation take place. I wonder, like, what is it, since you represent platforms over the past 2 decades, what is it that we're missing? From the outside in, there's so much, you're seeing a lot of criticisms about the platforms. But if you say that since you mentioned there is already technology in place, what do you think they're doing that we're not able to see, right? And maybe is there, like, what do you think of that judgment which will have some implications, but do you think something like that will also apply here in India, or you think that's going to further some more litigation here? I want to pick your brain on that too.
So first, let's begin by saying the concern of parents that excessive exposure of children to the internet, to a computer, to movies, to television, it's a valid concern. It has got to be addressed. There's no two ways about it. What is there? So to answer it straight, is there tools? Every app has a tool where there will be a reminder every 15 minutes. You can control access, you can prevent access. Every reasonable app has such tools built in there. Every app has a family plan. Every app has the ability for a parent to closely monitor what a child is doing. Now, let me go back to my childhood days. We had a carom board. We have exam tomorrow. We say half an hour I want to play just to relax. When has a child ever stopped at 30 minutes? Except that one boy or girl who is very resolute. Everybody else, half an hour becomes 1.5 hours. So that's the nature of things. What will a parent do? Finally come and say, up, now finished. Go back to studies. So that's life. My point is, these issues, so then you don't say the carom board is the problem. That's life. We've got to deal with it. And every app today has tools that I don't think we use sufficiently. We don't, because it was easy for us to take the carom board physically and keep it away, or take off the striker and say, now let's see how you play. That was easy. This is equally easy. It's just that we haven't spent enough time. It just takes 5 minutes for us to figure out how every app access can be controlled, access can be restricted, access can be restricted by time. The tools are just there. So I think, see, the concerns are valid. Nobody is ever saying the concerns are not valid. But my point is, the tools are there. We just have to got to use them. When it comes to judgments, there will be appeals. There will be some facts. And a cross-border repercussion of judgments always happens. Especially in this day of internet, a judgment in one country will always be referred to in another. But it is only a matter of time that you will get another kind of precedent. It's only a matter of time.
In the beginning, you did mention like one thing which is kind of lost out on when we talk about internet regulation in India is like the Consumer Protection Act. And I only refer to this because the sort of judgment or the reporting which we're seeing from the US about this case is it's trying to articulate this idea that the choices of the design choices which a platform has made, the algorithmic choices, the way they have constructed, infinite scroll, for example, is causing harm to the user. And the platforms were negligent. They were aware about this, but they were negligent. And as a consequence, therefore, we need to make them liable, right? That's a sort of legal theory which they're looking at. I wonder, and there's just like a hypothetical situation, do you think like that sort of argumentation is something you would see in the future here, where I'm framing this discussion not from the perspective of speech or access to information, but more from the perspective of consumer harm, right? Within the Consumer Protection Act, or like the law of tort in general. I'm just curious to see if like that sort of litigation is something you can foresee happening here now in India.
Nirmal, just let's imagine I and you are sitting together. We are scrolling through an app. I do it for the first 15 minutes, you do it thereafter. The app is never going to know, it's the same device. So therefore, every measure that is suggested is so susceptible to plain common sense answers that the answer does not lie without. See, it's like this. It's like saying, please put an expiry date on a cricket ball such that after you have played for 1 hour, on that day the ball should not move. It doesn't happen, boss, in real life. Yeah. And if you say, no, you have to design the system differently, the system will collapse. You can't design systems like that. nobody on this earth has ever invented a foolproof design, and reasonably speaking nobody will ever be able to. So therefore, like my perspective is, the problem with every technology is there, but the answer is not necessarily in the technology. The answer is usually in the user. It's the same traditional discussion: a knife in a butcher's hand, a knife in a killer's hand, and a knife in a surgeon's hand. The surgeon and the butcher are performing a useful function for humanity. The killer is not. It's not the knife's problem.
The only this also this brings me, I think just the construct of maybe the internet perhaps may change this, right? Like, so you have proponents who argue that, look, sure, in the traditional way it's not the problem of the knife, but at some point in online, the way this amplification is taking place, the way the spread is taking place, at some point there is this question, or what some people would argue is for them to take that responsibility. You cannot also say that it's the other person who's doing this, and therefore I can wash off my responsibility. I'm not liable. So I'm curious how you think about that, right? Like, if there is that algorithmic design, that amplification which is taking place, where do you stand on this side of the debate?
Nirmal, one thing, and I must in fact thank you for asking this question, is every reasonably large, major, or not even large, every large and every other conscientious technology company takes thousands of steps, not hundreds, thousands or millions of steps, has hundreds of employees, if not thousands, whose job is to ensure that bad content stays off. It's just that they don't talk about it often, so nobody is paying any attention to that aspect. Every entity puts up transparency reports. Those transparency reports will show what effort every entity has taken voluntarily to ensure bad content is not available on the internet. Bad content is limited today. It is limited not despite but because of consistent efforts. See, Ayn Rand says the first person who invented fire was likely burnt at stake in it. So, it's easy for us to say something's wrong, but we've got to be fair. We've got to see the kind of efforts that are taken, and the efforts are at multiple levels. Since I know I can say it, the efforts are at a technology or algorithmic level, at a product design level. The efforts are also at a human level. There is a human review. There is a constant and consistent endeavor at even a human level of review to ensure that bad content is kept out. The one reason why that effort is not seen, and again genuinely not seen, is the standard of what content passes in one country and what content passes in another is always different. And therefore, every country believes a lot of illegal content is available. But the fact is, if you have a situation where content that is impermissible in one country should not be circulated all over the world, it would be a slippery slope. So therefore, first point is, there is a lot of effort that is going into it. I don't want to take names because it's not necessary, but the charge that there are a number of engineers who are keeping people hooked, I am sorry, there are perhaps even larger number of engineers who are making sure bad content is off the internet. I don't think that is sufficiently recognized or that is sufficiently talked about. That's point one. Point two, how many times have we not seen the same movie twice? It's not the producer's problem. We spoke 10 minutes ago about both of us wanting to see the same movie that we have seen again. So I don't think it's a problem of either the internet or a social media company or internet companies. I just think it's about who we are as a human being, And we may have very many number of legitimate reasons to watch the same movie twice, and we may have extremely silly reasons why we want to watch the same movie twice. I just think we are more concerned because the medium has changed. The same thing was going on. We read and reread the same books unnecessarily, and we did not read the number of books that we had to read multiple times sufficiently, because there are some books that you can read over and over again. My grandfather has told me, my mother's father, that every time he read the Bhagavad Gita, he had a new understanding. So he wanted to reread it as many number of times as he wanted. I have never, so therefore, I don't think tech companies take a lot of effort, make a lot of effort. I think it's about time they communicate that.
I think I hear you. There is some effort, like there's a lot of effort which we perhaps as users we may not be aware about what's happening behind the scenes. Maybe a hard look to be taken there. I know we're close to time, so I'm going to close this with one slightly lighter section. At the end of every TechTicker, we tend to give out some recommendations. So because this is a recorded sort of podcast, I want to focus on 3 types of recommendations, which, maybe I'll take your help with. The first is in terms of, a new tech product or a tool. It could be an AI tool or something which is helping you at work, for your productivity or anything else, like whatever you think is helping you out. The second is, since we've been speaking a lot about tech policy movements, judgments, and sort of the kind of legislations which are proposed or otherwise, as a litigator right now, is there something which you're going to be looking out for in the coming year? Something which you think we should be keeping in mind as we keep track of tech law and policy? And the last thing is just something fun. We've discussed books before this call as well. But is there something from the perspective of tech, internet, etc., which you really want to recommend? It could be a podcast, it could be a book, it could be an article, it could be a video, anything, right? So yeah, we'll go through 1, 2, 3, whichever you want to go with first.
I'll go in the order. Tech product. I have found both Grok and Gemini very useful. It's just that I have figured out some fun ways of using it. For example, I went to Pondicherry recently. There were things I wanted to do. The best was to ask these chaps how to go about, how to plan my day. So those are kind of, we try to use large language models to do legal research. We have sufficient tools there, and we have some very good legal language tools also. For example, JurySphere is doing a great job there. So these tools, I think used well, are tremendously useful. For example, you could ask Rock to tell you a joke which has dry wit every day, and it will do a fascinating job. Some beautiful sentence. The other day it told me a quote from Oscar Wilde. It says, there are some people who spread happiness wherever they go, and some whenever they go. So, very simple things like this we can use. So that was on the tech product. 2, on books. There is one book that I have been reading recently by Akhil Reed Amar.
Okay.
There are 2. There is one about, I think it's called the Unwritten or Unspoken Constitution, something of that sort. I found that very fascinating, although it's not directly tech related. I found that very fascinating because there are so many assumptions we make about, and the US Constitution is much smaller. Even our own Constitution, there are things. For example, where does our Constitution say explicitly there shall be separation of powers A, B, C like this? So there are so many things. Yeah, what's the correct name? The Unwritten Constitution. I found that very, the most obvious thing, but told very well, told very well, and therefore very, very edifying. On technology specifically, on the history of Section 230, I think there's a book called the 26 Alphabets. I'll give you the correct name. The 26 Alphabets that changed the internet. It's a journalistic piece. about law, and that's why I think it makes for an easier read on the eye. It is not confined to, it's not a heavy lawyerly text. It is something that anybody can read. The 26 words that created the internet, because it gives us an idea of a time when the internet was first booming, people were dreaming. It gives a different, that's the same thing that repeated itself when crypto came for the first time. Said, no, we're going to create something supranational, we're beyond government, beyond law. So it helps when one reads those things to figure out what people had in mind initially. Those were the 3 books that I could think of. 3 products, 3 books. What was the other one?
The last thing I think is just more, what would you be on the lookout for in the coming year from a tech policy, tech movement perspective, a trend which you think you want to keep track of, or maybe from a litigator's perspective, there are cases around the world that you're like closely watching out for, and anything that you think from in the coming year you would really want to be on the lookout for, like you'll have your eyes open.
I think the next decade or so will turn on how well we regulate infrastructure powered by artificial intelligence. I think things will change at a pace that I cannot imagine today. It will be rapid. 2025 May, I sat in a driverless car in San Francisco. It drove me quite well. I parked on the side of the road where there was no traffic. It took speed when it had to. It's now in more places than one.
Yeah.
In 10 years, I think it will be reality. We'll have to then navigate allocation of risk in those circumstances. We'll have to navigate product liability. And I think as a nation, as a country, we should look at creating regulatory sandboxes so that the world's best innovation happens here.
Got it. Yeah, I think that's a good place to also end. Thank you so much. Thank you so much for the time. Thank you so much for this lovely conversation. I'm going to bring you back once again, in the future when another regulatory development happens. But yeah, thank you so much.
Surely. Thank you so much. Bye.